everybody. Happy Friday. Happy, let's see, daylight savings time. Happy, let's see, earthquake day. For those of you who know about it, who felt it, it was kind of crazy. I never even realized it was happening. Anyway, let's go. We have the dog of the day today. Let's see. Today we have Wyatt, and that's what, can you see Wyatt okay there? So that's Wyatt. And Wyatt is like a model dog. He belongs to Rob Thomas over at Comet Management. And I don't know if you've seen Wyatt in the past, but a beautiful dog. And it's very appropriate because I think Wyatt is over 30 pounds. I would guess Wyatt's over 30 pounds. And that's what we're going to be talking about today, dogs over 30 pounds. Thanks so much there, Crystal. So it seems like every time we have a new topic in mind for the following month, something else, either a piece of legislation or a case comes out that kind of trumps the topic we talking about the following month. So that's the case here. This case just came out. It's a very important case in New Jersey. It's a precedential case. It's a case that is going to be followed by lower courts, must be followed by lower court. If you notice, if you looked at the case itself, it was written by the Chief Justice of New Jersey's Supreme Court. So the Chief Justice of the New Jersey Supreme Court doesn't write all the opinions. In this one, I think the Chief Justice took some special interest in it, and he said, you know what, give that case to me, everybody. I will deal with it. I will write the opinion. Thank you so much. So as I usually say, this is for educational purposes only, not legal advice. There's no attorney-client relationship. There's no confidentiality. So the questions you ask, just please, especially when we're dealing with disability issues, please don't put anything in the chat that involves disclosure of healthcare information. So I am very biased for all of those who have been on First Friday with Fran before. You know I love dogs and I'm a dog person. I do have a problem with the plaintiff in this case, however. So in this case, what happened was there was a homeowner who started dating somebody, and the person was going to move in, and the condo association had a rule that said there shall be no dogs permitted in the community that are over 30 pounds. And the unit owner's girlfriend had a disability. She had an emotional, psychological disability, or at least she claimed she did. And the unit owner, the gentleman, reached out to the association and said, hey, you know, I'm thinking about having my girlfriend move in with me, and she has an issue, and we think we will be getting a dog, and we think the dog will be over the 30-pound limit. And before the association could give an opinion on whether or not the association would give an accommodation for the over 30-pound dog, the girlfriend purchased or adopted, I guess this was from a shelter, adopted a dog over 30 pounds. And in fact, the dog was 60 pounds, I believe, or 62 pounds. So more than twice the weight of the required dog, and decided to move in with the dog anyway. So we've talked about this issue in the past. A lot of times, at least in my experience, what triggers these types of, we'll say, a bitter dispute is not so much what the person is requesting, but how they handle it. So it's pretty, and by the way, I don't represent anybody in these cases. I was not involved in this litigation myself. But what happens is boards take that as kind of a smash mouth approach. You know, you're going to take my accommodation, right? It's one thing to say, it's kind of like a teenager. Mom, can I do this? No, you can't. And then teenager goes out and does it anyway. That's not going to make mom happy, right? No. You came to me, you know, you said, hey, can I do this? And you go out and do it anyway. So I have found that really ticks a lot of board members off, and it kind of inspires them to pursue members who break the rules. Even when, if cooler heads prevailed, they probably would not have. So that's the issue, right? We do, and I don't know if that's what happened in particular here, but I do know that after the letter went out saying, hey, can we have this accommodation? They did go out after the fact, before the association responded and got the dog. It's right in the opinion. So the problem that I do have with this person is during the testimony in the trial court, she was talking about the difference between let's see, big dogs and small dogs. And for those of you who have seen my dog, I have a small dog that's probably around 10 pounds. So I'm kind of I would call myself a small dog person. Yeah. And she says, small dogs don't comfort me because they are loud and yappy. And small dogs give her more anxiety rather than actually helping her with her anxiety. So I hope that all those small dog owners out there support me in saying equal rights for small and large dogs. But this person did not like small dogs, so she got a large dog, the 62-pound dog, and and there was testimony throughout the case that she grew up with a larger dog. She had emotional, psychological issues since she was in middle school, and that the larger dog, which I guess makes some sense, gave her more comfort and relieved anxiety. Again, I don't know why she had disparaged small dogs in her testimony, but she did. So anyway, so what happened here? The trial court, in my opinion, uh, trial judge tried to be cool with everybody, tried to be cool with everybody. So the people went out, like I said, asked permission, the association, before they could even respond, the people got the dog, the girlfriend moved in, they subsequently got married. And then the association was very unhappy with that. The association said, hey, if the dog moves in, we're going to sue you. And the resident said, if you do sue us, we will countersue you for Fair Housing Act violations and New Jersey's law against discrimination violations. So I do not suggest this approach, and I probably would have taken a very, very different approach for those of you who have talked to me about these issues. The association went ahead and sued, and the homeowners then counterclaimed based on Fair Housing Act and law against discrimination claims. What is the major risk with the fair housing type claims and the law against discrimination claims? Fee shifting, attorney fee shifting. That's why the title of today's seminar is the bite is worse than the bark in these cases. And the bite is attorney fees. The bite is attorney fees. The case doesn't talk about attorney fees or penalties or things like that, punitive damages. The problem is, though, if you decide you're going to be an association that is going to go after one of these issues and you are not successful, you will pay your own attorney fees, right? And you will pay the homeowner's attorney fees to a huge amount. Now, I have heard people say, well, I'm not so worried about that, Fran, because we think it may be covered under the association's D&O insurance carrier or perhaps some type of other insurance policy. Everyone in the world right now knows that insurance is in what's called a hard market, which means insurance rates are trending up dramatically. So you do not want to make silly decisions that negatively impact your insurance underwriting, okay? Because not only if you have claims like this that are litigated, you're going to increase your loss run, you're going to increase your claims history, and the insurance may just drop you, And then you wind up trying to get additional insurance coverage or, God forbid, winding up in surplus lines where your insurance coverage may double. Right now, it's a very, very ugly insurance market out there, right? Everyone is seeing their insurance rates rise dramatically. So I know I'm kind of putting the cart before the horse here, but that conversation should be held with everyone in these types of cases where there are civil rights or discrimination type issues or there are attorney fee shifting, right? Because not only are you paying your own attorney, you stand to pay your adversary's attorney fees. And if your insurance company is involved, you may wind up having significant insurance increases and or being dropped. The insurance company is not required to keep you. So keep that in mind. So service animals or emotional support animals, what is the difference? There are some differences, but given this type of case, and when I say, a distinction without a difference, maybe a distinction without a difference. There are differences in the law, so I don't want to downplay that. But the bottom line in these cases are, unless you have extraordinarily good facts, there's not much of a difference, and the person is going to be permitted to keep the animal. Okay. I have high-rise boards that hate it when I say that, and I've said it for years, and they've said, Fran, you just don't want to litigate, you just don't want to fight this person. And I say, listen, I'll be happy to make a couple $100,000 fighting this issue for you, but you're going to lose. You're going to pay the unit owner's attorney fees, and it makes no sense for your residents or community. And most of the time, not all the time, but most of the time, the boards have decided to get on board with that. And even though perhaps the accommodation request was presented in a more smash mouth way, they've let cooler heads prevail and did not wind up in a litigation that cost them hundreds of thousands of dollars and a loss of insurance coverage. So I generally the service animals are animals that do things for people, actually do things. So an animal, a seeing eye dog is the classic example that a lead animal that helps somebody who's visually impaired move about. But there are animals that can, my understanding is, can sense, for example, an epileptic attack coming on in some people. They can help open certain cabinets and actually do functions, can grab canes and things like that. So the service animals are trained animals that actually do things. Emotional support animals, on the other hand, actually do things, but not actually tasks, right? They help mitigate psychological, emotional type issues rather than actually opening doors, closing doors, things like that. Um, Establishing the disability, that's the first step. And in this decision by Chief Justice Ravner, he says, hey, listen, this is more or less the first time I've gotten this issue on my desk in the court before the 9 justices. So what I'm going to do is I'm going to lay out a little framework for how people should analyze these. And even though the defendant, counterclaimant, the homeowner said, I'm going to pursue the association based on LAD, the Law Against Discrimination, which is a state law, and also the Fair Housing Act, which is a federal law, we're going to construe this today under the Law Against Discrimination. So this is the framework for the state law against discrimination with respect to handicap and disability. So the first thing a person has to do is establish the disability. And what Chief Justice Ravner indicated was in New Jersey, based on his decision, the LAD, the Law Against Discrimination, disability will be construed much more, I think, much more broadly than the Federal Fair Housing Act may construe it. So generally speaking, under the Federal Fair Housing Act, to establish a disability, you have to establish that a major life function is impaired. And in New Jersey's law against discrimination, a similar type of language is included, right? So they're kind of parallel that way. However, what Chief Justice Ravner says, hey, when I look at LAD in New Jersey, there's another thing that it says. It says, first of all, it says a condition which prevents the typical exercise of any bodily or mental function. So that's very much like the Fair Housing Act, right? A condition which prevents the typical exercise of any bodily function or mental function. So that's what the trial judge relied on in this case. Like I said before, the trial judge, in my opinion, was trying to be cool. And what she said was, hey, I don't find that this plaintiff or counterclaimant, the homeowner, established that she has a disability because she hasn't established a prevention of a typical bodily function or a mental function, right? Apparently the woman worked, apparently she graduated with honors from college, et cetera, et cetera. So the judge said, you know what? I don't think she established it, she has a disability. However, like I said, where I think the judge was trying to be cool was she says, listen, you didn't establish a disability. However, I'm a chancery judge, I'm an equity judge, and I can do equity. I can do what I think is right. And she said, I'm going to let you keep the dog anyway. Go judge, right? Because the dog's a nice dog. She didn't say the dog's a nice dog, but she said the dog is well behaved. The dog hasn't barked. The dog hasn't attacked people. The dog has not created lots of noise. The dog apparently was picked up after, et cetera, et cetera. Didn't cause a problem in the association. So the chancery judge said, no, no, no. Even though I find that you are not disabled under the statute, I'm going to let you keep the dog. And what happened? The association appealed. Right? Why? Right? So I think the trial judge was trying to kind of split the baby, right? Solomon here, split the baby. And instead, they appealed, right? So the association appeals, and then of course the homeowner cross appeals, and the association says, well, listen, if she's not disabled, um, she can't keep the dog. And of course, the homeowner cross appeals and says, well, the trial judge was wrong. Yes, I get to keep the dog. Thank you so much, trial judge. But I am also disabled and I'm entitled to damages and attorney fees and all those other things that you get for discrimination against handicapped people. Right. And what did the appellate division say? The appellate division said, yes, yes, you are disabled. The trial judge was wrong. Okay. You are disabled as far as our interpretation of LAD is concerned, because in addition to the provision I talked about with uh, unable to have typical exercise of bodily or mental functions, it goes on to say any mental or psychological or developmental disability which is demonstrable medically or psychologically by accepted clinical or laboratory diagnostic techniques. In this case, the unit owner had her own medical people saying she had a long history of mental and psychological and emotional issues going back to her middle school years, right? So normally what happen in these types of cases is the association's attorney would go out and find an expert and have a psychologist, a forensic psychologist or someone like that examine the person, say, no, she's fine, she's a faker, she's lying, she just wants her 60-pound dog and this is all nonsense, right? That's how you would normally try to have a battle of the experts, okay? The association's the association's expert. So the association went out and hired an expert to examine this person. Now, this is the association's expert talking. His diagnostic impression of the homeowner was that she had bipolar disorder, major depressive disorder, generalized anxiety disorder, somatoform disorder, whatever, which I don't even know what that is, compulsive personality disorder, and borderline personality types. That was the association's expert opinion, right? And then the association is spending years in court arguing that this person is not disabled, right? And I understand why someone would try and do that, and they were actually able to convince the trial judge of that, because the standard that the trial judge was looking at was whether or not she had a inability to have a physical or mental a typical daily life, basically. Well, the Supreme Court, Justice Roberts said, no, 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 it's a two-test thing. If she satisfies the first part of the test, that's fine, right? Okay, there's a major impairment of function, mental or physical, but the justice said, hey, the trial court left out the second part of the analysis, which was if there is somebody who can establish the medically or psychologically by accepted clinical or laboratory diagnostic techniques that she is handicapped. Now, there was testimony which was given credence by the trial court that, among other things, and among all the diagnostics related at the trial judge, at the trial level, was that many times this woman apparently would have anxiety and fear, so much so that she would lock herself in her closet and then just cry unconsolably. I don't know what her background was, but when she had the dog, she was able to stay in the condo by herself. She was more comfortable in the condo by herself, and apparently she was able to not be in the closet, physically actually in the closet, for as long amount of time, and she could leave the closet. And there was no apparently question regarding the credibility of that, and the judge at the trial level gave credence to that testimony. Nevertheless, the case went forward, and in the appellate division, it's a three-judge panel generally in the appellate division. In the three-judge panel, two of the judges said, "Hey, you know what? We do think the trial judge was wrong in that she is actually disabled. However, we do agree that she can keep the dog, and we think that's an equitable thing that the judge at the trial level had the power to do, even though the trial judge didn't specifically find disability." The third judge in the appellate division said, wait a second, if there's no disability, right, and that's what the trial judge found, there can be no remedy, so she can't keep the dog, which that makes some sense too. Once you have a split court at the appellate level, it automatically can go to the New Jersey Supreme Court once you have a split appellate panel. So that's what happened here. That's how you wound up in the Supreme Court. Generally, if you don't have a split appellate panel, with certain exceptions, the Supreme Court can either take your case or decline your case, right? So here we had a dissenting appellate division judge, so the case went up. Step two, right? So first of all, in the framework laid out by Justice Rabner, is you have to establish the disability, which she did. Secondly, establishing the accommodation, this is the homeowner, must establish that the accommodation may be necessary to afford an equal opportunity to use and enjoy the dwelling. Then the question is, will the accommodation alleviate at least one symptom of the disability, not whether the accommodation will cure or eliminate the disability? So here I think it's pretty clear that this woman had testified, and it was uncontroverted, that she had a long history of emotional problems, psychological problems, and that she had a hard time staying by herself in the condo without the dog, and otherwise she wound up in the closet hysterical. These are really, really, in my opinion, pretty darn bad facts, right? I'm glad I didn't have the facts that we have here. So will the accommodation at least alleviate at least one symptom? Keep in mind, it doesn't have to cure the issue. It doesn't have to cure the issue, just helps with the issue. And the second question, will the accommodation enhance quality of life by ameliorating one or more of the effects of the disability, right? So it helps. You know, where you have to be careful in these bright line tests, some board members will say, no, we have a weight limit. It doesn't cure her condition. It doesn't make this all go away. So no, she can't have it. She hasn't proven that. Be very careful, because the answer, Justice Rabner, and in this case, I agree with him, is right. It's not you have to cure it. LAD, and also LAD does not require that a professional prescribe the emotional support animal. That is out there in the world, that you need a prescription from a doctor. No, you can have testimony that says this helps my condition, and that's what she did here, right? So she was able to establish through her own testimony. So that's what she was able to establish here. But she also did have medical professionals that say, hey, she needs the animal. The animal works for her. They didn't actually prescribe it, but the animal works for her after the fact, and it makes certain of her symptoms go away. The third part of the test, and it's really a four-part framework, is the parties must engage in good faith, interactive discussion to evaluate the accommodation and explore possible alternatives before denying the emotional support animal on alleged reasonableness grounds. And that apparently did not happen here. Right. In this case, apparently what happened is the association went forward, said, hey, you know what, you can have ADR, but even if we go to, I don't understand the rationale for this, but even if we go to ADR, we're still going to sue you. And that's in the court decision too. That doesn't make a lot of sense, because you're basically, in my opinion, saying you're negating the ADR process in its entirety. And I'm in the process of litigating an ADR issue right now, where the person, in my opinion, refused to participate in good faith ADR and mediation. And in my opinion also, that doesn't constitute participation in ADR at all. You can't come to ADR and say, no, 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 I just want to sue everyone. No, that's not fulfilling what the intention of ADR and mediation is. And I think in this case, the court was sensitive to that as well, where they said, you know, listen, you can't just have a couple nasty letters going back and forth and then say, I'm going to sue you, and then go forward and sue people. The part of the reason we have ADR and mediation in the community association field is to try and resolve these people where people live to these problems, where people live together amicably, and we don't spend years and hundreds of thousands of dollars in court. Now it gets to the tough part, right? So part 4, assuming the unit owner can show a disability, and assuming she can show that this requested accommodation helps mitigate or ameliorate her issues, and they don't resolve it in good faith discussions, then the association has the burden. So the burden shifts. The burden shifts from the homeowner having to prove things, right? Initially, the homeowner has to prove my disability, and the homeowner has to prove that this requested accommodation helps make my problems go away. The burden now shifts to the association must prove the accommodation is unreasonable. Does the specific animal, and this is the court's language, not mine, but does the specific animal pose a direct threat to the safety of others that cannot be eliminated or reduced by an acceptable level to an acceptable level? This is always a big challenge, right? So where are the biggest challenges in this case? And you've probably heard me mention this case before. The classic case of that is a case in South Florida where an emotional support animal was a pit bull that the gentleman wanted. He had PTSD from military service and deployment issues and returning to civil society. And was having a hard time coming back from his service overseas, and he needed a pit bull. And the associates, no, 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 you can't have a pit bull because I think it was overweight. And I think in that case, there was also a so-called vicious breed, whatever that is, a vicious breed classification. And the gentleman won the case. The association lost because they did not involve in these types of stuff. Different law in Florida, but similar in a way. So just be careful there that not only does the association have to engage in good faith discussions for possible alternatives. So, for example, some of the discussions you would have would be, okay, we have problems with big dogs here, but can the dog have a special leash? Can the dog be walked in a certain area where perhaps smaller people or smaller dogs in particular are not being walked? Because I mentioned this to you before. I've had several cases now where people have been attacked, and I've had cases where, excuse me, other members' dogs have been attacked, and in at least one case, the smaller dog was killed. So there are reasonable safety issues. That not only this, and the court did not touch on it here, but I think we should think about it too. One of the things that um, is kind of a bit of a weakness in dealing with issues case by case is sometimes if you're focused on the case, you can leave out a global perspective of community association living or living in society generally. The unfortunate thing is courts and judges can only deal with cases and controversies in front of them. They can't do advise. They generally don't do advisory opinions. They don't just make stuff up or give advice to the world. No, that's left to the legislature, right? And the executive implements those legislation, right? So courts generally don't do that. But one of the things here, besides the safety issue, what else are we talking about in this case that really wasn't mentioned much? So the president testified at the trial level. The reason we have this type of rule and regulation in place, Judge, is because we feel that bigger dogs damage the landscaping more, right? The bigger dogs damage the landscaping more, and we have some other concerns about bigger dogs. Okay, well, you can have, handicap or not people, you can have requirements that say you must pick up after your dogs. Your dog can't destroy the landscaping, right? It makes things harder on management, it makes things harder on the board, perhaps more expensive. And this wasn't highlighted in the case. That my experience has been that bigger dogs tend to bark louder, tend to bark louder, right? I hate to say this, tend to have bigger poop, right? They tend to have bigger poop, bigger dogs, bigger poop. And they also can be noisy even without barking. So I've had complaint letters from homeowners where just big dogs jumping off and on sofas may be causing noise, right? So when I say a global perspective that judges can't generally reach is, so one of the things that's been in front of New Jersey Supreme Court for years now, decades, is affordable housing, right? Affordable housing. So one of the ways that courts, or at least the global community addresses affordable housing is they build high density housing, right, where people are kind of living on top of each other, so it's more affordable. They're not using as much real estate. It can be more environmentally friendly, but unfortunately, sometimes you have, especially in affordable housing, flat style condominium construction, you have people living on top of each other. So you can hear the people in the unit next to you or above you sneeze, right? So that's an issue too that the court, again, didn't touch on, but that can go to reasonableness. I'm not saying it's a reasonable thing that will be upheld by the court, because I think in this case, even if there was testimony that there was noise upstairs or downstairs from a dog jumping off a sofa, the court would probably still have had this unit owner win. But you can really bring, I think, more than just health safety in terms of a threat of a dog, an animal. So, for example, I may have mentioned this before to all of you, that we had a situation once in South Jersey where a person who had a service dog, in this case it was a seeing eye dog, that allowed her dog to poop all over the common area. And we sent her a letter saying, hey, you can't let your dog poop all over the common area. And if you do, you got to pick it up. Now, I don't know how a blind person picks up poop after they're seeing eye dog, but I'm sure there's a procedure. And initially, her reaction was, we're going to sue you. We're going to get a civil rights attorney. We're going to do all kinds of nasty things to the association, et cetera, et cetera. You know, and I think eventually she was convinced that the association had no ill will toward her or to her dog. We just needed the darn poop picked up, right? That's all it was about. It was just reasonableness. And I would say that it's unreasonable for anyone to say, you know what, the association is going to let you have your dog, whether it's an emotional support animal or a seeing eye dog, poop all over the place, and you don't have to pick it up, or you don't have to make some kind of arrangement to have it picked up. So reasonableness, I think, in my opinion, again, Justice Rabner may not agree, but it should be part of the discussion when the association is discussing accommodations over things. You can have the discussion about landscaping. You can have the discussion about safety of other dogs, other small dogs in particular, or children, or leashes, or muzzles. So all those things should be part of this discussion. But what Justice Rabner highlighted here was that there were no discussions like that. And that is a critical part of the process. So it didn't happen. So what happens? The justice says, okay, the case is reversed. Number one, I agree with the appellate division, I find her disabled, and she was entitled to an accommodation because of the disability. I don't have sufficient facts on record right now, so I'm going to send this case back down to the trial court. And the trial court is going to decide a couple of things. They're going to decide whether this 62-pound dog was actually a reasonable accommodation for this person's disability, and whether or not, from the association's perspective, this accommodation was unreasonable. Because the association was arguing that it was unreasonable, the association was arguing also that she didn't really need this size dog for an accommodation. So the case is going back down. It's not over, even though it's the homeowner won at the Supreme Court. It goes back down to the trial judge. Okay, in this case, the trial judge, though, is not going to handle it herself because she's a chancery judge. She's going to send it to the law division. And what is the law division about? Whenever you hear law division, it's about money, M-O-N-E-Y, money, right? And I think the Supreme Court Justice Rabner may have said this a little bit tongue in cheek, that between now and the time it gets in front of a jury, because he highlighted the fact that this case is going to wind up in front of a jury when it sends it back down to the trial court, the parties may wind up discussing a possible way to settle this case, right? And in my opinion, I think he said that a little tongue in cheek, because what he is highlighting there is that the association stands to be stung for lots and lots and lots and lots of attorney fees, right? Because it's already been established on the record she's disabled. It's established, in my opinion, pretty darn thoroughly that this dog was a reasonable accommodation. And I haven't seen anything in the record so far, you know, it's not a complete record, and Justice Rabner said that, that established it's 100% reasonable from the association's perspective. The thing to keep in mind here is be very, 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 very careful when somebody asks for a handicapped accommodation. Too often, people on boards with a knee-jerk reaction will deny it, will let the level of hostility take over, emotions take over, personalities take over, and you wind up in court, and before you know it, there's no going back. And all that does is make lawyers rich. All that does is make lawyers rich. It really does. So these cases, and every court who deals with these types of cases, and HUD, you know, Housing and Urban Development at the federal level, everyone says you have to sit down. You have to sit down. You have to have a discussion. You have to have a way to accommodate these types of people if we reasonably can. If it's totally unreasonable, okay, no, you can't. And the association will win that case. But my opinion, hard pressed to win that type of case. The other thing to keep in mind is, what should we do? What should we do if our governing documents say no pets? Well, first of all, these are not pets, right? They're emotional support animals, or they're service animals. But what's the biggest problem for board members? They always go, Fran, this isn't right. They see Mary Jane walking her giant dog through the lobby every day, and that's going to get 10 more dogs coming into our building. That's true. But is the answer challenging every one of those people who wants a dog? Or is the answer taking the no pets provision out of your governing documents and instead putting in reasonable rules and regulation that are focused less on the actual animals and more on what's permitted and not permitted? So, for example, you can't have an animal that pees in the lobby. You can't have a lobby that an animal that pees in the elevator. You can't have an animal that barks all night. You can't have an animal that is left alone unattended and is barking. So the problem with the no pets thing is, what it leads to is more and more of these cases. And you know this, you've seen it in the newspaper. Although I think many people who have emotional support animals, they have them for a reason, and they're a good reason. There are a lot of people, if they want a dog in a no pet community, they can get a note from a psychologist, a psychiatrist, or another medical profession that easily meets the burden of the Law Against Discrimination or the Fair Housing Act. And do you want to find yourself in those types of situations on a regular basis if you have a no pet provision? I'm not telling you, again, this is not legal advice. I'm not telling you if you have a provision that says no pets, take it out. I'm saying if you do have that provision, you should have a discussion with your board and management over whether we should take it out and instead implement a framework for addressing animals in a rational way. Because, like I said, it is too easy in today's world to be able to substantiate a handicap that will open the door to a reasonable accommodation argument. Does that make sense? And all of that is attorney fees and costs. I have never been involved in a case so far where I had to hire an expert on behalf of the association to challenge someone's representation that they're handicapped, because it just doesn't make any sense. You're going down a road of no return in many respects. Now, there may be cases where you want to do that. I haven't seen any yet in my practice, but it's very challenging to win a type of a case like this. You don't want to be what this case is, which is called a test case. You don't want to make new law. You don't want to be the association that says, and the Supreme Court justice said this in this case, this is the first time I've had a case like this coming this far in the Supreme Court. You never want to hear that, because you don't want to be the association to litigate the test case. You don't want to be the association that spends hundreds of thousands of dollars, generally speaking, to make new law, because making new law costs crazy amounts of money. As I said before, and I don't say that because I'm afraid of litigation or we don't want to litigate, but as a from a practical standpoint, you just have to keep the business judgment rule in mind, check your emotions at the door, and make sure you're going through the 4-step framework that Justice Rabner laid out in a rational way, right? The other thing to keep in mind, and this is just, I guess, something that we should all keep in mind, God willing, and we all live it long enough, we will all be handicapped at one point or another in our life, right? We are. That's just a fact of life. And I want to have my little dog with me when I am. So all of us are going to be handicapped if we live long enough to some degree or another. And I think that plays into the context even here. And I believe Justice Rabner's, this may not be true, but I think it's true. I believe Justice Rabner's wife is an employment attorney. And I think my recollection is she's a very well-known employment attorney. So many of these housing-related discrimination issues in many ways track the analysis of reasonable accommodation in the workplace. So I can imagine that he's very sensitive to this type of framework and analysis for things like handicap, reasonable accommodation in the workplace. And it's a framework that in many respects is similar to the workplace and the housing context. So it's very understandable that the case came down the way it did. What else should I talk about? Remember, keep in mind, because everyone thinks about ADA, Americans with Disability Act. Generally, American Disability Act is not what we talk about in community associations. We talk about the Fair Housing Act, and we talk with the law against discrimination. So people say ADA, ADA, ADA. It's not really ADA, but the Fair Housing Act, the analysis is almost identical to the ADA in terms of analysis. But keep in mind, as Justice Rabner said, um, the requirement for finding a handicap that it substantially limits one or more major life activities does not constitute the only basis under LAD, right? Even if you don't meet that, even if it doesn't substantially limit one or more major life activity, you can qualify if you have the opinion of a mental, psychological, or developmental disability, which is demonstrable medically or psychologically, right? By accepted clinical or laboratory diagnostic techniques. So here, it didn't happen right at the trial level yet, but it's going to. We already know we have enough in the record. So keep in mind when somebody says, "Oh, that doesn't substantially limit any of your major life activities," that's not the end of the story in New Jersey because LAD provides broader coverage. So be very careful about that as well. I will go to the questions now. I'm rambling a little bit. I'll go to the questions right now. I'm going to jump into the chat now. Oh, yes. Mark says so this is what happens when you spend other people's money. So that's a good point. That board members have to keep in mind that they're spending the membership's money, whether it be actual out-of-pocket dollars or the carrier's money. Can you require annual certifications from all ESA owners? No, I would say no. I don't really know the answer to that, Norman, but my answer would be no under Justice Rabner's opinion here. The more interesting question, Norman, would be, I shouldn't say, you have a good question. I shouldn't say more interesting, but a little bit more complex question is, what happens if this dog dies, right? This particular dog dies. Does she still need a big dog? I think she's going to say yes. And you probably have to go through the process. You have to do the application, et cetera. Or can she go get a 30-pound dog? The answer is probably going to be no. But to answer your question more particularly, Norman, is I think in this case you couldn't require an annual certification because she would say it makes me happy, it continues to make me happy. So I think that a court may suggest that once you've established the handicap and the fact that this is an accommodation that helps her, they would say you couldn't take it away. The question would be too, and I don't know if this happens, I'm not a psychiatrist or a psychologist, might somebody be cured? What if they're cured, right? Or what if a new medication comes out like Ozempic and it cures something, right? I think Ozempic cures obesity, they're saying, but which is fantastic. God bless America. But what if they came out with a cure for whatever situation this lady had? We have the silver bullet for bipolar syndrome. Awesome. I don't see that happening in the short term, and I think it's probably not worth the effort to go through any kind of annual certification. So without any medical documentation, a person can claim that they need an emotional support animal. Yes, Alex. And the Supreme Court specifically says that without any medical documentation, they do have to establish a handicap, right? Under the first part of the test. So you got a disability, you have to establish that, but they don't need a prescription. My client here or my patient here must have a 60-pound dog. They don't need that. And even from the medical documentation standpoint, it gets a lot more complicated than that, Alex. So you may have to have some understanding of what their limitation is, right? So there are people who have limitations that are obvious, right? So there are cases where people have obvious limitations, whether that's psychological or physical, and the board still challenge them on that. That's going to get you in trouble if it's obvious. In this case, it may not have been obvious, and I think that's why the association probably pursued it, because apparently the person had a good job, did well at her job, had good reviews, and graduated with honors from college. So they said, hey, there's no problem here. But she had the other side of this where she did have medical professionals that said, hey, she has serious problems, and the association's own expert agreed with it. Oh, wow, Marcia. All this is clearly in favor of the dog owner. My question is, suppose the animal was disruptive to the neighbors or the homeowners would not curb or clean up. Does the association have the right to rescind the accommodation if they signed the agreement but did not or would not follow the rules? I don't think she, well, first of all, I don't think she has to sign an agreement for the accommodation. That's number one. So I would not say you must sign an accommodation agreement. I think if they're entitled to the accommodation, they get it, whether they sign an agreement or not. And by the way, you can't put special deposits on there. You can't charge special fees, et cetera, for these types of things. Our situation is that many homeowners have surfaced claiming fear of some of the dogs. Many of the owners are leaving their pet droppings all over the community and obviously allow their dogs to use the lawns when it is against the rules. The rest of us have no rights at all, which is the complaint of other homeowners. We have rules that have to be signed that are taken directly from the township's website. So, Marcia, I am 100% with you on your concern. So I generally, this is not true all the time, but I generally feel that there are not bad dogs. They're not bad animals. They're bad owners, right? Who don't deal with their pets or animals if they're not pets, but if they're support animals or if they're emotional support animals or service animals in a responsible way. That goes to the reasonableness test. That goes to the reasonableness test. So generally speaking, under my interpretation of this Supreme Court case and the various laws is you couldn't bar someone's dog because they didn't pick up after their dog. Okay. I think you could fine them. I think you could fine them. I think you could post fines on their account. You could send them a violation letter. You could suspend membership activities for not picking up after the dog. So, for example, they may not be able to use the clubhouse, et cetera, et cetera. But I don't believe that you could take away the accommodation, right? Because then the person would not be able to use their housing, their unit or their home in a way on equal footing as to other people. Now that ends, right? And I think the court alluded to this when it was talking about safety. That ends when you have situations where, say, for example, it's not a nice pit bull, but it's a pit bull that mauls people or mauls dogs. Then you may have a situation where you can have the animal removed from the community, right? And even in those cases, myself and another attorney here, David Merritt, litigated a case several years ago where we were trying to get a pit bull out of a community. It was not a handicap accommodation dog, but the judge was very reluctant to allow the association to give the association an order banning it from the community. And it wasn't until after the fact that the dog bit somebody that the judge seemed to be willing to go along with that. So it can be very difficult. I am not a big proponent of the one bite rule. You hear the one bite rule, like all dogs are good until they bite somebody. That's not so helpful when the dog is a pit bull. It's one thing if the dog is my dog's not here today, but if my dog bites somebody, my dog is like gums my finger. He can't right. So the question is, what if you do have a dog that's 62 pounds or 105 pounds and can be really dangerous? So Marsh is right that just because an animal is a service animal or an emotional support animal doesn't mean all bets are off. The dog can crap all over the place and destroy your grass and destroy your common hallways and bite people and attack people's dogs. No, and the court acknowledges that. It's just that you just have to be very careful when you're doing that analysis. You must speak to your lawyers, get your lawyers involved early, because I think that if you get your lawyers involved early, although you may spend attorney fees up front, it will save you hundreds of thousands of dollars in the long term. So, Marcia, you raised really good points. It's just that the laws against discrimination with respect to the handicap are going to favor granting the accommodation and making it in such a way that even though it's an additional burden on the association, if the burden is not extreme, the courts are going to say, allow them to have the accommodation. Okay. So that's a really good point. And if people are irresponsible owners, they should be brought into line with your rules and regulation. Maybe I don't hear you discuss this, but was the counterclaimant suing based on the dog as an ESA or a service animal? Emotional support animal. Is that Ivan? Yeah. Hey, Ivan. So it was an emotional support animal. So she was suing as emotional support animal, commercial. Sorry, counter complaint. counter-complainant. The other thing the court mentioned here is, and the trial court struggled with this a little bit, and the Supreme Court made it quite clear. So keep in mind, the association sued, and it was more or less a contract claim. The association said, we have these governing documents which constitute a contract. You're breaching the contract, and therefore, we get damages against you and get rid of the dog. The counterclaimant said, this is a discrimination case based on the emotional support animal and my handicap. What Justice Ravner said, and this is true, is the analysis of the discrimination claim, even if it's a counterclaim, comes first, right? Takes priority. Because at the end of the day, if there is a handicap and there is a violation of failure to accommodate that reasonably, it's going to trump the contract claim anyway. You see what I'm saying? So even though the plaintiff was the association, said, hey, we have a contract here, the Supreme Court saying, no, it's a discrimination issue that trumps, right? The law trumps what's in your governing documents. And we've talked about that a lot. Since the homeowner didn't try to discuss alternative size dogs before acquiring the animal, why does it not have a bearing on the case? So it does have a bearing on the case from the point of view of, I think, public relations. And this is where the smash mouth approach, and I've had the fist smashed, the Heisman Trophy given to me lots of times by people saying they need emotional support animals, or they need, I shouldn't say service animals, but in the emotional support animal context, when the board was very critical of whether or not there was a handicap and whether or not they needed it as an accommodation. There should be discussion. You're right. There should be discussion. But that is going to weigh on both parties, and when in doubt, it's going to weigh on the association more. That's very clear. And in this case in particular, the association was, I'll say, very assertive in asserting that they were going to go forward and file suit, even notwithstanding an offer of ADR. So I think your point's well taken. There should be a discussion from both sides, but the court is going to put more weight on what the association did. I think in that sense, any aggressive animal must be reported to the association animal control in order to prove history of same. Otherwise, it's hard to prove the history of the animal. So Al's making a good point. If you do have an animal in your community, whether or not you have pet restrictions, any type of animal, putting all the handicap stuff aside, it should be reported if there are incidents. And the reason for that, and Al raises it and highlights the issue, is if you wind up in court, whether it's municipal court or in the law division, chancery division, the court's going to want a record. This can't be just like, oh, I don't like this dog scares me, this dog looks intimidating. You have to have a record. Otherwise, people like me who go to court have to have nothing to rely on to show the judge that, hey, there was an incident back in July, there was an incident in August, there was an incident in November, etc. The judge isn't going to want to hear, I have a problem with dogs. We have a rule in the master deed that allows one dog per unit. Can all of the residents in the unit claim they need an emotional support animal to circumvent the rule? Alex, that's a good question. And the answer is, it doesn't matter how many people are in the unit. The question is whether the one person in the unit could say, I need 2 dogs, or what about 3 dogs? And the question then becomes, when is that reasonable? When is that reasonable? When does 40 cats become unreasonable, right? Because we have had several situations with cat ladies, and we've had to go in there and deal with them, right? Because you do wind up, if you have lots and lots and lots of cats out there, you are going to ultimately wind up with situations that may impact health. But there is no hard and fast answer to your question, which is the number of animals, right? What if you need 3 hedgehogs, and 3 hedgehogs makes you feel really good about yourself? Okay, maybe you need 3 hedgehogs. I don't know. But the question is, you still have to go through the framework that Justice Ravner described. Does 1 hedgehog not do it for you, but 3 hedgehog does? Right? Or does 2 cats do it for you, and you don't need 3? So the answer is, you go through the framework. Is it reasonable? Is the requested accommodation unreasonable? I would argue that 40 cats is unreasonable, or 15 cats is unreasonable. I don't know if 3 cats is unreasonable though, or 3 dogs. That's where things get funky. If you have 3 dogs, what is the impact? Are they small dogs? Are they little tiny hot dog dogs, dachshunds, right? And they don't make any noise, and you can just hear their claws on the hardwood floor. So that's a good question. There's no real answer until you put it through the framework and find out if it's a reasonable accommodation. If the association has the ability to fine unit owners, can we assess fines against an owner whose ESA barks repeatedly and disturbs? Yes, Miriam, you can. You can. You have to offer ADR. You still have to go through the process. I imagine that person, whoever he or she is going to say, that's not reasonable. It only barks once in a while. I don't leave it alone, et cetera, et cetera. But that's a good question, and the answer is yes. If the animals do things that are unreasonable, the association take action on that. Even though, and this isn't fully fleshed out in the opinion we're talking about, is the court seems to suggest it only goes to life, health, safety. In my opinion, life, health, safety is involved with things like continuous barking, not picking up pet waste, et cetera. So I think the answer is yes to that. Do you have regulations in place already? Do I have regulations in place already? I don't know, Al. I don't know. So we have done pet regulations for various associations, and we could, come up with them if you need them. What are reasonable fines for disruptive dogs, noisy, aggressive, poop or pee on the hallway, carpeting, and indoor facilities? So the question, Rose, is usually your governing documents will specify the amount of fines, whether it's an escalating fine, and then they cap the fines out, I think in today's world, at $5,000. The other thing, too, is most governing documents have a provision that says if the unit owner, through their negligence or purposeful acts, destroys portions of the common elements, the association can repair the common elements and charge them back. So look in your governing documents, not just for fines, but also for remediation, okay, expenses, and who does the remediation and at what person's expense. So usually the association's documents have a provision that you can do that and charge them back. Make sure you always offer ADR when you're doing that type of process, because the person will request it, number one, and make sure the board is not using it as a pretext for harassing a handicapped person, even if you don't believe she or he is handicapped. Be careful. I've had a number of associations who say, this is how we're going to get after that person who claims to be handicapped. She's not really handicapped, and I saw a spot on the carpet, and we're going to jack her up for that. No, do things reasonably. Remember, we're all going to be handicapped one day. Question, is it legal for an association to say that owners can have dogs, but renters cannot? No, you can't do that. No. Renters, just like homeowners, are entitled to rights under the Fair Housing Act, the law of discrimination, and are able to use housing on an equal basis. We adopted a town's ordinance for fine level. Okay, so Al's saying they key their fining provisions and amounts based on what the town does. But also check your governing documents, Al, just to make sure it's consistent. Does the owner who is severely allergic to dogs have any rights? Yes. Yes, they do, right? Because what's that allergic person? Handicapped, right? So they're handicapped too. We're all handicapped in one way or another. I can't dunk because my hands are too small. I can't hold the ball. So I can jump. I used to be able to jump at least, but my hands are not big enough to hold the ball. So the answer is yes. So that person would be handicapped as well. And that goes to reasonableness of the various accommodations and the request for accommodation. We actually had that case in Seabright, New Jersey, where the person who was supposedly allergic had a very well-known attorney as a husband and a very aggressive attorney as a husband. And just again, the smash mouth approach. Fran McGovern, if you let this handicapped person have their dog and let that dog ride on the elevator, what we're going to do here is we're going to sue the association because my wife is severely handicapped and I'm going to make all kinds of money off of you because under the Fair Housing Act, she also is entitled to accommodations for her allergy, et cetera, et cetera, et cetera. So that's a conundrum. We were able to get out of it through discussions, right? So we had discussions, we engaged in discussions, and fortunately that association, which was a high rise at the beach, it might have been West Long Branch or Long Branch actually, had 2 banks of elevators. So we had the doggy elevator and the non-doggy elevator, and everyone agreed to that. So she didn't let it run loose in the hallway. So it's a really good question because allergies can be a handicap, and and probably are handicapped under this case, and I think they would be, and what is reasonable under those circumstances. At some point, I won't do it today because we're already long for time. I'll tell you my story about the stroke victim and the hardwood flooring. Some of you may have heard that before, but it's a very ugly case about handicap. I would also like to know if it is legal for owners to have a dog and tenants. You checked that already? Tenants cannot be treated differently than the unit owners. Can we require people to show that they need accommodations? Can we do it annually? Again, Norman, I think we talked about this before. You can't, I would not go about doing it annually. Once they've established the need for accommodation, I would say it's okay. You know, unless it's a situation that is unique. So say, for example, we see issues with accommodation. So handicap parking where someone may have a hip replacement, and then after they recover from a hip replacement, they're perfectly fine. And in fact, sometimes they're much faster after they get their hips replaced, and they're much more mobile after they get hip replaced, and they don't need the handicap parking spot. So there are situations where the handicap does go away and is cured. I haven't seen it in the ESA context. Deem it a list disability, right? So I think Patricia McGill, not McGill, Patricia Gill out there is saying that it would be a disability, and I think it would. Marcia, I have documentation that says the ESA letter is renewed annually, as is the license from the township. The ESA letter must say that it is the doctor's medical opinion that the patient needs the comfort of an animal for emotional support. Yes, so that's the problem, Marcia. This, and you're asking really good questions. You're probably a lawyer too. But you're asking really, really good questions. The Supreme Court justice here is saying, no, we're not going to permit that, right? Once you've gone through the framework, if the person has established a disability, if they've established that their proposal is a reasonable accommodation, they get the animal, right? Unless it's unreasonable, unless the association can prove it's unreasonable after the discussion period. So even though the township regulations or the licensing provisions may say that the animal must be recertified or the person must prove year after year that they're actually handicapped, I would say that the Supreme Court would say it doesn't matter. The law against discrimination, New Jersey law against discrimination trumps that. Again, this is not legal advice. Speak to your own attorney, but I would say that the LAD would trump that. What if an individual refuses to give you medical documentation? So again, it comes down to not necessarily an indication of medical documentation. It can be either or, right? So it can be under the LAD, one of those two criteria, right? A condition which prevents the typical exercise of a bodily or mental function, or any mental, physical, or psychological developmental disability which is demonstrable medically or psychologically. So in the first instance, so say for example, I'm going to try and make up a hypothetical, which I don't know anything about. I don't know anything about these disorders, but say somebody came into your community and it was very, very obvious that the person had, let's say, for example, Tourette's, and had very difficult time speaking, and it was obvious to everyone. Nobody contested that, and the gentleman or the woman said, "Hey, this animal helps me," and nobody contested that really. I think he gets it, whether or not he has a doctor's note or not, or whether she has a doctor's note or not, right? Where things get odd is in the case like this, where it wasn't so clear that the person had a disability, and it wasn't clear in terms of typical functioning, because like I said, she kept a good job. She had good job reviews. She had excellent grades in her college. But she, in fact, was able to establish under the second prong of the analysis that her medical providers there were able to document her disability. So documentation may not always be necessary. So I would just say, be careful, be careful. Many times under today's world, I am very low bar for documentation. Set a very low bar. You know, there are cases out there you're going to wind up litigating, I think, if you challenge the medical documentation too much. What documentation should the association ask for? Well, I think, first of all, it depends how it comes up. Really conscientious people come forward and they say, hey, I have a child with we'll say brain damage, and that child is very much comforted and very much calmer when things are exciting around the house. And sometimes that person will even bring the child in, and it's very, very obvious. In those cases, you go, what are we talking about? Why are we having requests for documentation, et cetera, et cetera? Where the things get tough is where it's not obvious. If it's not obvious, I think you can actually go and ask for documentation. It doesn't have to be from a doctor. It can be from a social worker. It can be from um, other professionals. In this case, it came from, I believe, a nurse, and it came from a social worker. And then eventually it got into psychologists and psychiatrists, including a forensic psychiatrist. But talk to your attorney about case by case, what you should request. I don't want to give you a blanket statement because it depends on the facts. Can you require ESA owners to hold insurance policies regarding property and liability? So I would say not differently than anyone else, right? I wouldn't say you need a special endorsement for dogs. I would say not differently than anybody else. They should be treated the same. Can the association require all those with dogs use the service elevator? No, no, Rose, but that's a very good question. And that comes up a lot of times. So we represent a lot of high-rise communities, towers, if you will. And what they always want to do with ESA animals is make them use either the loading dock steps or the service door around back rather than using the lobby. That is insane. You're making people with disabilities second-class citizens in your community, and they are not able to fully use, right, their housing accommodations, right? Imagine that, being, hey, go use the loading dock. And I actually had a client who did that until I went to a meeting, and they said, well, of course we send them through the loading dock. And I said, are you out of your mind? Why don't you just write her a check for 200 grand right now? Right? That would be very generous of you. Some lawyer out there in Atlantic County is going to make a fortune because you're doing that. So be careful. But it's a good question, and it can be confusing, right? Let's see. Can the associate service elevator? No, I would not say you can make them use a service elevator. What if there are dueling disabilities? If this is a unit owner that has an ESA, but the adjoining owner has anxiety that is made worse by a barking dog in the next unit. So the answer is you're getting into the reasonableness area, and what becomes reasonable. Are there other ways of mitigating it? Are there times, so we've had situations like this where it's not so much that they're next to each other, but the person with anxiety with respect to dogs has anxiety when the person who owns the dog is walking the dog past them and they're in the hallway or the elevator at the same time. So for example, can you come up with alternative approaches where, okay, I walk my dog at 7:30 in the morning, I walk the dog again at lunchtime, I walk the dog again at 9 o'clock at night. Okay, can we all agree that this is the times you're going to be in the common hallway? Things like that. The question is, can we do that? Can we work it out? And putting everything else aside, you have to engage in that discussion. Let's see. Just an FYI, nearly all service animals have training and do not bark unless there is a reason. That's right. I mean, we focused pretty much today on service animals, which are trained. Service animals are trained. Thank you for highlighting that, Marcia. ESA, however, are simply pets who comfort the owners and do not require any training. So true. So ESA are not generally trained. They are not pets, however. So watch using the word pets alongside ESA, because once they're ESA animals, they come outside the framework of pets. What happens if the ESA is owned by a guest, an offspring, or a friend? Same analysis, right? So same analysis is people who have, again, in this case, started out with a boyfriend-girlfriend type situation. They eventually were married, but whether it's a visitor, same analysis applies. A handicapped person has every right to visit their friend in their home, right? A handicapped person has every right to have a friend over. And if the friend has an emotional support animal, that animal can come into the building. Same rules apply, though. Can the dog poop all over the place? No. Right? Can the dog pee in the elevator? No, we can't do that. That's not cool. We don't like that. What happens if the ESA is, okay, we talked about, can you restrict where the animal can go? For example, in the clubhouse or around the outdoor pool or other amenities. Generally speaking, the answer to that is no, Alex. It can be a reasonable analysis because you got to remember that this is about a handicapped person's reasonable right to use housing accommodations. Swimming pools are housing accommodation, clubhouse are housing accommodation. So they would come into the clubhouse, they would come into the swimming pool area, etc. The question is it reasonable in the context of things like what could I imagine? Sauna. Like say there's a sauna. You have one of those hot box rooms in the basement of your clubhouse. Would that be reasonable? I don't know. Would that be reasonable to the animal or the other people? I don't know. But would you want a German Shepherd in your sauna? I don't know if that's reasonable or not, but you'd have to do the analysis first. Our service elevator goes to the lobby. Oh, okay. So Rose, you said your service elevator goes to the lobby. Can you require them to use the service elevator? It depends, I would say, under those circumstances. Does it make them out to be a second-class citizen or not? I mean, that's really the question. If they're identical, maybe like that allergy case that I told you about in Long Branch, maybe it could be no big deal. But if it makes them a second-class citizen, you're going to have a problem. Can you require bark collars for barking dogs? You know, I've never used a bark collar. The answer is I don't know, but I think that that could be part of the discussion as a reasonableness of the accommodation. So say, for example, somebody had an emotional support animal that just barks constantly and disturbs everyone. That's not reasonable. That's not reasonable. Get the dog out. Well, before you say get the dog out, I think there should be a discussion of what can a bark collar do? Can the dog go to a special training class? I think someone mentioned there are training classes that dogs can be trained not to bark, things like that. So before you say get the dog out, a bark collar may be something that may be part of the discussion. I don't know if they're humane things. I don't know if they're good. I have no experience with bark collars, but it may be an option. So I think that's it. I hope I didn't talk too much today. That felt really fast, and it's 20 after 5. So, all right. Well, it's good seeing everyone. Have a great Friday night and a great weekend. Watch out for that eclipse. Don't burn the eyes out of your head. Good seeing everyone. Thanks again for attending.